Today in our Ask the Expert segment, we will be examining the area of business protection. As with anything in life, there are correct procedures that you can follow to help keep you out of trouble. And running a business is no different. To further explore this topic, we ask our local business expert, Brett Thompson from the Thompson Law Group in Virginia Beach, about some of the proper procedures you can do to keep you and your company safe.
Right, so most small business owners think that if they have incorporated, they've filed their documents with the State Corporation Commission, they think that they're safe. They don't know about a doctrine of the law called piercing the corporate veil. And a plaintiff's attorney, if you will, in a lawsuit which would look at your corporate entity and see if they can go through it and get to you individually and your individual assets. And in order to prevent that, we got to take a look at three things, right? Number one, we have to make sure that you are treating the company as a separate and a distinguishable separate entity. All right, you have to be at arm's length between yourself and your entity. Number two, the commingling of funds, very bad. And number three, keeping the corporate books and records tight. What I mean by that is, so number one, we want to treat the entity as if it is a separate person, all right, separate and apart from yourself. So you have to file all your documents correctly. You have to have your State Corporation Commission documents correct. Your own tax ID number for the company. The company must have its own bank account. You have to run all the funds for the company through that particular separate entity. Number two, commingling of funds is a red flag, all right, and it's very attractive to a plaintiff's attorney. If you commingle funds, if you are going grocery shopping for your house out of the same company account as you are buying your materials and whatnot, very bad. That's a red flag, and it could jeopardize the corporate entity. Number three, you have to keep up all the formalities of the corporate entity. You have to, if you are a stock corporation, you have to file your annual report each year with the State Corporation Commission, and you have to file your annual registration fee to keep in good standing with the State Corporation Commission. All your banking account documents must be in good standing. Your corporate minutes, you must memorialize your meetings in your corporate minutes. So all the formalities that are required under the Virginia statute for that corporate entity must be met. So as long as you are treating the company as separate and apart from yourself, you're not commingling funds, and you are keeping all the corporate records in accordance with Virginia law, you should be fine. And we're not going to pierce the corporate veil, all right? But just be aware of that.
Thanks, Brett. For those that want to learn more, they can connect with Brett Thompson and the Thompson Law Group in Virginia Beach at tlgva.com or call them at 757-486-3333.